Lordship, item 16 would be not before me, Lordship.
Okay.
And other list, I'll give it to the court master.
Item number
16,
16. Okay. 16. Just before I need the bike without one of us.
This I cannot mention. This is, and there's another matter, Lordship, which is not a FC matter. Item 20.
May I please your lordship, I'm for item 20. I'm on behalf of MSP Chaudhary. Kindly adjourn for a week's time as my senior is incapacitated at small.
So let us see what it, why it has come. Habeas corpus matter. Item 20.
Consent has been taken from the other side.
No, it's not a question of consent. It's a habeas corpus matter. We have to be certain why we are adjourning.
Item 20. You've mentioned. But if you give a mention to it. Adjournment. Just request.
It's not habeas corpus.
I see. Washing on the closer report. Special SIT.
Both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List on. Give it on Wednesday, 21st August.
Lordship, can I kindly request, like, my senior is on medical emergency leave, so kindly like give us more weeks time. Medical.
Okay. You want 1 week's time?
More than, more time,
More time, 2 weeks.
3 weeks.
You request your senior to make, because we are not convinced that this matter needs to be heard by a division bench.
Yes.
So
definitely.
therefore you come before the court after 2 weeks or 10 days.
But this, we don't feel is a a matter which can be taken up by a division bench. The prayer is only for setting aside the order of what you call closure report. So closure report doesn't come to a division bench. It's perhaps wrongly registered as a criminal writ petition. This would be a normal criminal petition. So that is the point.
Who is the counsel for the petitioner?
MSP Chaudhary,
What is her full name?
Banali Chaudhary.
Just after 2 weeks on a date to be fixed by the office.
We're giving you 2 weeks.
Much obliged.
Only on one question, whether it should be there before the matter to be listed before a division bench, or it should be taken up by a single judge by re-registering as a criminal petition.
Much obliged.
Next.
Division bench, item 1 for motion.
Legal worship. My lord, the petition was declared foreigner by informed judgment dated 30/11/2022. Order is at case 85. My lord, here in this case, my lord, father is voter in 1966 and have NSS annex number 3, page 43, 11 portion at page 44. Abdul Hamid, my lord, at serial number 94. Father's name is shortly written as A. Hamid. But in 97, voter list lastly will find my name is with my father and mother. Page 49 is 50 is the 11 person. Abdul Hamid, father. Then Khadija Khatun, mother. Ahmad Ali, his name is written Ahmad Ali, is also known as Ahmad Ali. So, my lord, petitioner is father. In 2010 voter list also.
Just a moment. What is your explanation about your voters voting in the different
My
villages?
lord, there is a shifting, my lord. We have explained in the WS, my lord.
Where is that?
My lord, page 33, there has been two shifting. First shifting we have stated in pair 15 of the WS. Then my lord, sorry, 16, paragraph 16. Then my lord, another shifting, my lord, it has been explained in paragraph 18. So my lord, there is some name variation also that has been also explained.
So we are issuing notice calling for the records. But you have wonderful people cross-examining. So AR Sigdar for the petition, Ms. Verma for standing counsel Hani, Ms. P. Barwa, standing counsel for the ECI, Mr. K.D. Chaudhary, DSGI, and Mr. P. Sharma, government advocate. Notice call for the records. Extra copies in course of the by Monday.
My Monday, my
Extra copies within 19/8. Mail to the satisfaction of
my
SP border
Gwalpara.
Gwalpara. You'll have to appear before within 10 days. You will appear before within 10 days.
My lord, 14 days will be better. My lord.
Right?
15 days, my lord, we need some time to collect the copy. My lord, we need some time to collect the copy.
Copy will be available today itself.
You have any grievance in this court number 7?
My lord, sometimes,
Delayed.
I think, my lord, 14 days will be
The
better
delay-
You can make
convenient.
it 1 week, then it is good, Lordship. Lordship has given considerable time and is bargaining on that also.
Because if within 1 day it is not, within 2 days if it is not given, then I am aware of which matters orders were not uploaded. We are working very hard. 10
Right.
days.
Item 2,
My lord, this case, my lord, decision on contest. My lord, here in this case, my lord, apart of the merit of the case, we have a, my lord, a ground, my lord, about the maintainability of the proceeding. Lordship may kindly have a look at the
But when you are
notice.
moving two matters, it will always be a 50-50. One we have given, this we have to reject. But she does not remember this, here the procedure does not remember when they were shifting. No, those things
My
are
lord,
there.
that may be possible for a
No,
woman, my lord.
No, and nobody will forget shifting. Those are very hard times when people shift from one village to another. And if they do not know, that means they are
My lord,
not the
the-
correct people.
shifting is adjacent village, my lord, to adjacent village.
Hmm?
Shifting is to adjacent village. My lord, 66, they are voter in Bagmara Chor, then 70 also.
The Kabinama is
Then
not
my
there.
lord, Bhatnabadi, so very adjacent.
Kabinama is not there.
No, my lord, no Kabinam. My lord, here, DW2, mother was examined. And mother is also voter. My lord, in
She is voted in 1997,
My
not
lord.
prior to that.
my lord, in 97 voter list,
That's what it is.
89 also, my lord,
97.
89.
For 97, where is her voter list?
87, 89 also.
Hmm?
89 also, madam. At page 104. Mother is 80, voter in 89.
Where is her evidence? Mother's evidence?
My lord, oral evidence, lordship will find at page 79.
79.
Yes, my lord. Annex 10.
No, this is cross-examination.
My lord, cross examination.
Yes,
Sheep at page 75.
75.
The learned tribunal has picked up some
Where is
negative
the,
point only because there has been some handwritten amendment.
where?
My lord, at
Where
page,
is the 1970 voters list?
yes, my lord, 1970 voter list at page 65. Pandagular at page 66. Pierre Ali is the grandfather and Javed Ali is the father. And mother is voter with father in 97, 89 also. My lord, these delays are, my lord,
Lordship, between
Sorry, dear.
1970 to 97, there's no voters list. They have to prove the continuous stay, Lordship.
89 voter list is also there.
He's now you see he's relying on this page 66. And if the family names of the family members match, then it will be difficult to discard this 66, what do you call this 1970 voter list, merely because there is no continuity.
Lordship may examine the matter, Lordship.
There is no disclosure of any date and
Yes, my lord.
age.
This, my lord, remote village, my lord, of Saur area people, my lord, lady, my lord. That too, she is aged about 60 years at the time of deposition.
You see, there are two ways of looking at it. You are looking at it that she is a member of he belongs to the Char community area and therefore illiterate. I may take a view that she is not saying because she wants to conceal.
My lord.
It's very difficult. People will not remember those days when they are proceeding for questioning the citizenship.
My lord.
At that point, to forget. Because the opinion otherwise is not so bad.
My lord.
The
Prime
prosecutor does not
evidence is-
remember the dates when they were deciding.
Prime evidence is there, my lord, 66, 70 voter list parents are there in the voter. And mother was examined.
Because you see, there are so many gaps. Went to
My
school,
lord,
went
there
to
are,
school, name of the school is not known.
my lord, there are decision of this own court in Hyder Ali case, paragraph 46. My lord, if the gap period voter list is produced, that would have been a proper explanation. But for that, for not furnishing that,
not
no
that,
negative
Not
effect,
that.
no
She went to the
defective.
proceeding, went to a school. In cross-examination, she does not know which name of the school. These things are very,
My lord,
very uncommon.
my lord, the wrong, in a long day back, she read in a school, my lord. I forgot, my lord. Really sorry, dear.
No, she produced a
my lord.
certificate.
She produces a certificate and then she
Produced a
forgets.
certificate.
Certificate. Yes, ma'am. Because on appearance before the tribunal, the on many occasions the tribunal, the member, the proceeding become confused, my lord. They become confused, my lord. Then also nervousness also. Nervousness also. But prime evidence are there, my lord. And my here in the writ petition, apart of the merit, I have a challenge on the maintainability of the proceeding. The notice contains two charges that cannot be in the light of the Sunakha case, my lord.
It's it has not been struck out. That's all.
No, my
It's
lord,
a
that should
standard
be
notice.
struck out. Why not? When you are when
It's
the
a
charge
standard
is against me, yes, my lord, doubting my citizenship, it's a very serious. The consequence of the proceeding is very serious, and you are coming up
You have to
with
raise these issues
in a
before the
casual
tribunal.
manner. That cannot be. That is the view of this
Did you
court.
raise these issues before the tribunal?
It's a legal issue, my lord.
It's a legal issue. Therefore, you have to tell us why it was not raised
My
before the
lord.
tribunal. You are entitled to file a review within the time frame.
Because the gap is not being filled up. Let us see the school certificate. The school certificate does not have the seal and signature.
We are only to see how the evidence.
My
has
lord,
been
the
appreciated.
headmaster was examined. My lord, headmaster was examined. His evidence
Where is
can,
where is the document first?
my lord, my lord, examination headmaster, my lord, at
No,
page
the document,
85.
the school certificate. Where is that?
School certificate. Not annexed in the writ petition, my lord. That
Okay.
will maybe in the record, my lord.
Where is the
Lordship may
evidence?
call for the record, my lord.
Where is the evidence?
My lord, at page 85. May I read out, my lord?
Just a moment.
I know OP Jomiran Nessa. I know her from the year 1986. I was working in the school which was situated near the residence of OP at village Bhatnapeti. I know OP's father Javed Ali also since the year 1960. He was studying in the same school where I had studied at 52 number Bagmarat Chor LP school. While I was surrendering my service as a headmaster in 1637 number Alut Bhatnapati Chor LP school NC, I had issued a certificate in the name of OP Muhammad Jomiran Nessa, which is exhibited by OP as Exhibit G, and Exhibit G1 is my signature. I have produced today the admission registered book. The extract paper sheet of the admission registered book of the year 1984 to 1986 is exhibited today on mark as Exhibit H. In the said paper sheet, office name was enrolled at serial number dated 1/3/1986 at column number 6. Her father's name was also shown as Javed Ali. Address was recorded as Bhatnapati Chowk. In column number 10, the student's age is recorded as 6 years, 1 month. And at column number 16, I have put my signature dated so and so. She was studying the school from the year 1986 to the year 1989. After studying class 3, she left our school. This is my lord's evidence in sheet, my lord. So my lord, even if no voter list or availability 86, 84, 86 is there, my lord, it as per this evidence. Only read up to class 3, my lord.
That's why we said when we started, that this is perhaps is not a good case. The mother who came as DW2,
My lord.
her evidence is also interesting. She does not disclose where she was born, brought up. She does not disclose about her own identity. No proof.
My lord, she disclosed that she was voter with her husband in para 10. And the evidence in sheet. Also in the cross-examination.
You see, there's a big gap in the evidence of this DW2, page 79. Look at it. DW2
My lord.
who is DW2?
My lord, the mother.
Mother. You see, she does not give the name of the husband. If that is not given, the proceeding is her daughter itself.
Cross. Yes. But she has stated about her husband death.
So that's okay. Husband's name is not there.
My lord, the others number the same husband or the thumb impression in the affidavit are mine. My engaged counsel has made me understand the entire contents of the affidavit. I have not stated that Jamiran Nessa, the OP is my eldest child. I have not stated how many children I had not. I had apart from OP, I do not know the date and year of my daughter's birth. I do not remember when she got married.
Okay, you only get the advantage of calling for the records because to dispose it off, we need the records. But we don't think there's any infirmity in the opinion. You're not satisfied.
Prima facie. is the case.
Uh,
Rest is what comes out of the Pandora's box when we call for the records.
Yes, ma'am.
Mr. Yes, the counsel for the petitioner. Ms. A. Verma for the home. Ms. P. Barwa for the ECI. Ms. P. Devi appearing on behalf of Mr. R.K.D. Chaudhary, is DSGI. Mr. P. Sharma. Government advocate. Notice call for the records. Extra copies within 19/8/2024. And bill subject to satisfaction of SP border.
SPB Borpeta.
Borpeta. list on receipt of trial court record, tribunal's records.
Deep level.
Item 3 for admission.
But here, my lord,
Myanmar.
Here, my lord, what happened, my lord, the second person also, Habibullah is also repudiated on 2023. Both of them have been now repudiated, my lord.
Both of
they-
them have been deported.
Yes. Rotated. The second one, first one repudiated prior to 2020 itself, my lord.
Writ petitioners.
Government of right.
There are two writ petitioners.
Yes,
No,
there
two red petitioners. The Azizul Haq was repudiated prior to my lord, 2020.
Oh, they have
Only-
been deported where?
My lord, the Habibullah has been repudiated to Bangladesh, my lord.
But they are claiming to be Myanmar nationals.
No, initially, my lord, there was doubt that they may be from Myanmar. So Myanmari the government of India, my lord, made an inquiry, given asked the details, given details of that person and for verification of nationality. They denied, my lord. The Myanmar authority denied.
Yes.
Yes. Thereafter, my lord, it is later come to know that he is from Bangladesh. Yes, petition, the address given is Bangladesh. So
No,
later,
we understand that, but all the communications,
yes, yes.
That was made, then Myanmar government wrote back that it was, this address was not found.
So
but someone must file an affidavit to tell us that they have been duly deported.
yes, my lord, I will file an affidavit to that effect. Both of them have been deported in the meantime. I will file an affidavit to that.
Because with the,
Yes.
with
Yes,
the,
so we
That
can
has to
close.
be on record.
with the proof of handing over, because
Yes.
otherwise we don't know.
Yes, yes.
Mr. A.M. Khan, the counsel for the petitioner, the petitioners. Mr. Arcade Chaudhary, the DSGI, and Mr. J. Pang, and counsel for the health department, home department. Mr. P. Sharma, Leonard, government advocate. And Mr. A. I. Ali, Leonard, standing counsel for the ECI, are all present. Next slide. Upon instructions, Mr. J. Pang, Leonard, standing counsel for the home department, has submitted that the petitioner number 1, namely Azizul Haq. This is, I'm putting a flag. Page 2. Yes, Azizul Haq, alias Azizul Haq, the 3 names, huh?
Yes.
Was deported to Bangladesh on
I will give details.
okay. No, because you see, what you are submitting is contrary to the document on record, 7 January 2022.
Yeah.
The petitioner, namely Azizul, has already been repatriated to Myanmar on
Yeah.
30/10/2020. That's why we are asking you that.
He has been, my lord,
Your letter from KK Sharma, ACS Joint Secretary, 7 January 2022. This is addressed to Ms. Burma.
And also in 5/3/2020, your lordship, in that order also reflects.
The petitioner number 1 is repudiated, my lord.
You see the order of 10-1, 2022. Second paragraph.
Because if somebody is somebody is from Bangladesh, you repatriate him to Myanmar, it'll again be a very difficult situation.
Voted for policy, like,
Right.
voted correction. Policy, like, last order of was. Bangladesh because there will be a submission near the last order order. এখন affidavit declare correction কৰিব কৈছিলে। Lordship, in the last order, Lordship has indicated something. There was perhaps a incorrect submission made. Your Lordship will see the last order, Lordship.
29-7.
I had pointed it out, Lordship, that they were from.
Okay, Mr. Agiri Chaudhary is so and so. We should take note of statement of the unconstitutional government as regarding evidence that they have application will file. Ah, yes.
There was perhaps Lordship some incorrect.
But you were supposed to file. Interpretive application, or they were supposed to
They
file.
were supposed to file.
I will file, my lord. I'll file by.
Yes, yes, yes.
No, problem is,
Something had
there is,
happened,
my lord,
instead of Bangladesh, it came as Myanmar in the queue.
no, that was on the basis of instruction because in the meantime, during that time, my lord, the state government and central government was communicating to the, my lord, Myanmar only. Later on, it has come to note, later on, they were, my lord, that's right. I'll give details, each and every details when they have been reported, where they have been
No, because
reported.
then you'll have to do some extra work. If if according to you, the state government, the petitioners are from Bangladesh, then for deporting them to Myanmar, you have to recall them and give it to the proper authorities.
My lord, where, that's why, my lord, I'll give details where they have been deported, when they have been deported, my lord. I'll give each and every details, by next week, my lord, no issue. I have all the information set here.
Because if these people are deported to Myanmar,
No,
then perhaps Mr. Khan is appearing pro bono.
no, my lord, my information is that the petitioner number 2 has been deported to Bangladesh.
No, that's okay.
That is confirmed.
No,
Only,
I'm not on
only-
that.
yes,
Please do it early, because if both people are deported, then Mr. Khan is appearing pro bono.
Yes.
So we want this to be finished fast.
my lord, I don't know whether he has any information to that effect or not, whether they, because
No,
as per my
deportees, he will
information.
not have information.
Sir,
If he's a devotee, he will not have information. Now from Bangladesh, they can't contact him. From
Yeah.
Myanmar and Bangladesh, they can't contact him.
Probably the petitioner number, what petitioner? Pagoti report.
How much time?
Within 1 week, I can file, no issue. my lord. Your lordship may fix in first week of January, August,
September.
No,
or September, first week of September.
you can file is, nobody's questioning that, but
No.
will you file?
No, I'll get the details, my lord, where they have been, on what basis they have been, my lord.
Can file, we are not questioning. Will you file? That is the question.
Yes, I will file. No,
I don't say that last time. Stop.
Myanmar.
Next question. Let a detailed affidavit of the deportation of the petitioners, both the petitioners, be filed by the competent authorities in the Home Department, the State Home Department, within how much time?
within 2 weeks, my lord, your lordship may fix in 8.
Within
After the question.
2 weeks from today, list on
9 or 10.
9/9/2024. Okay.
Alright.
Mr. Khan, on the next date, you please be prepared on which date, what is the letter and which order. Give us a detail of that. Write it down in a piece of paper and give it to us.
Item 6.
Yes.
Oh,
Mr.
maybe,
Bhuya.
Lordship. Basically, I have challenged this opinion, Lordship, on basis that the evidence in the opinion, evidence did not discuss anything regarding evidence, Lordship. And here, only two documents, Lordship, basically discussed two documents. One is Gamura certificate and school certificate. Basically, because of emblem and other things that to discuss. And that's the opinion is the format, basically. And Gawa has at least evidence, Lordship, and procedure evidence and cross-examine, but nothing is in the opinion. Lordship. Basically, I'm challenged this, Lordship. On that ground, Lordship, the opinion.
But it's a well settled position that with the state emblem, the documents become inadmissible in evidence.
Lordship. But the evidence of the Gamura evidence is not discuss anything. My question is that if evidence against me, that has to discuss, Lordship. No discussion, Lordship.
Where is the opinion?
Lordship, page, Lordship, it's from 63, 62. Relevant, Lordship, page 65, Lordship. Hard argument both the parties in the all the exhibit well only to consider and regarding evidence nothing was nothing. In the same thing, I have a citation in the list of this course. 2-3 cases I have a similar situation, Lordship. Demand beg, Lordship. You, Lordship. Because see, I can place, Lordship. That are even.
কিন্তু রেফার করেছে রাইট
কি হয়?
কিন্তু স্টেট এমব্লেম কেন রেফার করেছে
দেখো, basically the evidence
এটা কি
কিন্তু কেনেকুৱা ধৰণৰ discuss নাই কৰা থাকে ইমানটো evidence discuss কৰিব লাগিব
সে গাউয়ার সার্টিফিকেট
evidence discuss কৰা নাই। Basically 9-10 Lordship.
No, Mr. Bhuya,
Lordship.
you see, if the documents which has the state emblem is rejected, then obviously there is no linkage. The evidence, even if it's not discussed, will not prejudice you,
But
because what can be proved by documentary evidence, the oral evidence will be deemed to have been excluded.
paragraph 10
Paragraph?
Lordship,
10.
paragraph 9 Lordship. May I read, Lordship? The reference by the SP border in respect of the status of the citizen of petitioner as to whether she is illegal migrant or India, according to the fact in issue, before the tribunal is whether petitioner is Indian citizen or whether he is able to establish citizen prior to succession. Fact in issue, expression fact in issue means include any facts which makes on facts existence, not the nature, and action any right, liability, asserted or denied by any suit or proceeding necessary follows. Explanation whenever under provision of the time being for civil to paragraph 10. The aforesaid intervention itself gives the petitioner proceed a wider choice of evidence in order to prove her citizen by fact from which either by itself or connection with other facts, the existent knowledge, nature or extent of any right, liability or disability asserted or denied in the proceeding necessarily follows. Accordingly, the petitioner has a right to rely various facts which must be relevant keeping in view the fact in issue. Once the petitioner places the evidence, the tribunal is bound to consider each and every such evidence in order to decide the relevancy and admissibility of the evidence. The source of relevancy and proof of content thereof in case of documentary evidence is not same. Relevancy relates to the facts of fact issue before the tribunal, which are undoubtedly the facts pleaded by the proceeding and the degree of veracity that can be attached to it. So the said exercise requires discussion and reasoning. And if there is no such discussion, then it will amount to non-consideration of particular fact pleaded resulting, for example, principle necessarily affecting the proceeding. Once the document held to be relevant, then comes to issue of proving the document and contents thereof. While searching the relevance, the tribunal is bound to consider the oral evidence. Also, along with the documentary one, all facts cannot be proved only by documentary evidence. On perusal of the MP opinion, it is apparent that like 6 documents, but learned failed to discuss 4 documents. But after picking 2, as referred here, the member even failed to take note of the oral evidence, which are very much on record and certified copy of the in the decision we are to consider the opinion. Let's another
Last part.
Here we would also fourth question, good question also that not considered. And one thing last page for last line, non-consider of any evidence, whether it helps the petitioner or not. Possibly the petitioner, if the evidence recorded, the finding that aspect must be recorded and presented missing. As such, we are left no option but to interfere with the then says that this amount to error happened. That doesn't also have losses. This amounts to non-concern, amounts to error apparent lordship, but I could not find the line lordship.
Because the question, Mr. Bhuya, is that same question, I'm just reframing that question. You see, if a document itself is inadmissible, even after remand, the status doesn't change.
But I basically challenge this opinion lordship. That's and court does on that point does remand. That's true lordship.
Yes,
All the
My
other.
submission is also
all
same,
the
since
cases,
the
same
documents are, they do not link the proceeding directly to the documents lordship and they are inadmissible. So maybe that is the reason, the
No,
last
you-
line it says
but we
lordship,
have a different set of question.
Miss Lordship,
I come to page 56.
56 Lordship. Down below.
And the cross is wonderful.
Yes,
So this gives a proof, even if the document is excluded, then also the oral evidence that the father was a voter in the 1970, that becomes a link. The evidence which was absent
yes, Lordship.
is brought in the cross examination.
Yes, lordship. Absolutely. That.
And the father and mother being alive, if they come to depose for their daughter.
But
Lordship.
somebody came in this cross examination. Now this is a positive evidence. Somebody comes and says that, yes, I know.
Yes.
Yes,
No question at the time arises when the tribunal.
Lordship may fix this up for hearing, Lordship will also prepare it.
Because if this is there, page 56 is there, then we were of the opinion that it should have been remanded again. Because
Lordship, the father and mother didn't come to depose for their daughter. If there,
That the whole problem is that there is no finding by the tribunal.
no, exactly,
Respect
Lordship.
of this. So
At least one line ought to have
at
been
least
there.
one line.
Yes, one line would have.
Huh.
Or Lordship may remand it back only on this specific ground that these two documents, the Gaubura certificate ought to be reappreciated and opinion passed. Leaving aside
No,
all other
we won't
aspects.
say that.
that we can do, once you submit before us, or if you submit before us, then notwithstanding not recording, it causes no prejudice to the petitioner.
This can be re-examined, Lordship. This is what I'm saying. This evidence which has been given and she has not taken this into account in her opinion.
See, it can be taken into account, but whether any prejudice otherwise is caused or not.
Lordship, that would be the opinion of the tribunal. I cannot.
That is the argument we expect from the state to tell
Yes.
us that remand of a matter, yes, only if you find, yes, prima facie, some prejudice is caused. But if you argue that no prejudice is caused, document is not admitted, this evidence does not, even if taken on a face value, does not provide the linkage, why remand it back? Decide it here.
Lordship, I would have made that submission to decide
Yeah,
it
we are
here.
not
but the
advising you
thing
to
is,
do
My
that.
friend has submitted some decisions where it like says that if evidence is not appreciated, it has to be remanded back. So if that precedent stands, my submission will not stand in front of that lordship. So
If you want a remand, we'll remand it back. If you say that, yes, remand it, we'll remand it back. But then we'll have to record that council admits that this matter requires a
yes,
relook.
lordship. My colleague says that we would like to look into it and next date may be given, lordship.
That's the most prudent suggestion, Commissioner.
Lordship, a short date may be given.
You suggest there's a calendar in front of you.
First week of September, lordship.
Also, it's a represented on the prayer made by Mr. Verma, standing question for the Home Department. List on 2/9/2024. We're keeping this document.
Problem.
Item 8.
But instead of all this, we are again reiterating. I think the Home Department should seriously take up the matter to impart the training to the
FT members.
FT, not members, the lawyers, to teach them art of cross examination.
AGP, the additional AGP.
Whoever is there for your
Yes,
home,
they did conduct lordship last year also, but I think the AGPs also keep changing lordship.
no, but did you attend that? No.
Mr. Payam had attended that.
Was it satisfactory?
Repeat much, is it? I will ask Mr. Payam to reprise this for lordship. Deepak ही बोला गया. ये तो नहीं होना चाहिए. तो मैं तो नहीं होना चाहिए. हमने तो इसको नहीं माना. Last order साथ में कुछ बात करने में. Ram Mandir. Not instruction and indicators.
Item 8.
Lordship, I just saw the order. We were supposed to furnish some instructions. We'll have to check up, Lordship, if those instructions are there.
Oh. No, no. It's well done.
Lordship may fix it up. And Mr.
This appears to be a matter of Mr. G.P.
Oh.
Bhowmick.
Uh, he's not well, and one girl appears in between sometime.
Huh? Yes, that's why.
No, no.
Not well, Lordship, physically.
No, that's why he's there. So therefore, we'll have to inform the parties to take alternative measures or
Yes,
his
yes.
junior.
Last order, a junior her appeared Mrs. M. Ho Lordship. And we were supposed to bring in some instructions. We'll have to just look into it, Lordship.
So any,
Lordship may fix it up next week
this
sometime.
M or HORE. Please give us a call. You just see because
Yes, Lordship.
Item 8.
For the instruction.
I think this has come for the first time after issuance of notice in 2021.
Yes, Lordship.
The trial of records have come. We only need to find out if they are on bail. We have taken the bail. I don't think there's any other thing
It's
required.
Kamrup, Lordship. We can find out if
Ah.
bail has been taken or not.
Because the trial court records have come. If you want to go through it, you can go through it.
Yes, Lordship. Below cover to yellow version, Kamrup is there.
Because here here you will find that the stand of the proceeding is that he was born in 1945
Yes,
and
Lordship.
there's no reason recorded to.
They have a registration certificate also at page 20.
Yes, that's why we wanted you to go through the trial court records and just see. No representation from the petitioner. How all the respondents are represented. For answer justice, the matter stands adjourned today. List after 2 weeks.
Item 9.
Malika Pandit. Malika Pandit. Yeah. Malika. 20. So then to mention to how you like it. We find little comments.
Nine. Mr. A.M. Ahmed.
Item 9.
Here also, you'll have to examine the trial court records. The projected case is that the brother was declared as a Indian.
Yes.
Page 32. Just see that.
Lordship, our file is.
No, you take this. You take this. Take it.
Lordship, whether the proceedee, in his written statement, her brother had mentioned that she's his sister. So if that is established, then
That's why we wanted you to go through the trial court records. and
yes, Lordship.
find it out. You can check this, you can give it to the court once after some time. In the meantime, we call the next time, we adjourn this matter.
Yes, Lordship.
Just see the trial court record. If that link is there.
It's there, Lordship. We'll check it out.
Thank you. Same order, none appears. They are visible. Into this matter since it's on today. Yes,
After 2 weeks, Lordship.
Item 11.
We have extra copy of your petition. This one, item 11. After 2 weeks.
You are there.
Item
They are
number
receiving it
9.
after 2 weeks. Let them go through the trial court records.
The wrong file has come.
No, it's okay. The record is present, Mr.
A.M. Ahmed.
A.M. Ahmed.
No, I'll put on it.
Nota. क्या है मारेगा बात
Present, pays for adjournment.
publish.
Mr. A.M. Ahmed, when consider the petition, pays for adjournment, there is allowed. All the respondents are represented. Please start with the case.
This week.
Yes.
The petitioner case before the learned tribunal, madam. She claimed that he is a citizen of India by birth and her ancestor was the indigenous people of Assam. But my lord, he annexed all the documents, but he could not exhibit the 1966 voter list. But in affidavit, she stated that his father had no landed property earlier, but subsequently he had purchased a plot of land. But the thing is that the subsequently she obtained the voter list 66 but could not accept. And there are two cell deed, my lord, Annexure 9 and 10, my lord. By one cell deed 1959, my lord, his grandfather purchased a plot of land of 2 acres something, my lord. And subsequently in 63, my lord, her grandfather gifted 11 acre of land along with the 2 acre, which was purchased in 1959, to the father of the my lord, petitioner. My lord. A chance may be given, my lord, to produce that document before the tribunal, if your lordship permit. Otherwise, link has
Where is the father's land document?
my lord, which has been exhibited. No, 1960, Annexure 9, my lord.
Page.
page 59, ma'am. Grandfather,
59.
my lord. And translated copy, page 62. By Karna Prasad Sarkar, my lord, Red Rajmai Sarkar, Opankar division, my lord. And he purchased the land from the Navadip Chandra Sagolia. In the schedule, my lord, the land was situated in the village Sagolia, my lord. 2 biga. And in the schedule, my lord, 1 east, my lord, Kamini Sarkar, south land of Amini Kumar Sarkar, west my own land, and north your own land, my lord. I mean, it's the grandfather's land, my lord, in the schedule, my lord. And these 2 bigger land, subsequently, my lord, gifted, my lord, Annex 10, page 68, along with other 11 bigger of land.
These land documents were not exhibited, no?
No.
Where is your written statement?
Return estimate, my lord, page 31, my lord. At paragraph 4, my lord, he claimed that he is a citizen of India by birth, the whole ancestor of the Assam, the indigenous population. And she belongs to the Hindu Rajvanshi community.
Where is this 1966 voters list?
My lord, page 75. Her father's name, my lord, Hari Prasad Sarkar.
Register.
Purnaprasad Sarkar.
Father's name?
Purnaprasad Sarkar. Hariprasad Sarkar.
And your mother's name? Mother's name?
Mother's name, my lord. Monteshwari Sarkar. My lord, her father married, had 3 wives, my lord. First wife Rangeshwari, then Aina Sarkar, then my lord Monteshwari Sarkar.
Lordship, I have not gone to Lordship.
Hundred. My
The voters list which you have produced
My
are uncertified copies. They don't constitute a proof.
Yes, my lord. That's why, my lord, the CTC has been not been taken into account, but subsequently, my lord, voter list of my lord 1970, that was exhibited, my lord, and thereafter 97 voter list was also exhibited, my lord.
Certificate copy.
Yes, my lord. No, in order, my lord, it has been discussed, my lord. In Indian order also discussed, my lord.
Where? Oh, certificate copy, yes.
Yes.
What is it saying?
But exhibit 6 and exhibit 7, my lord. Only the voter list of 1966 could not be exhibited because the Angus Council had not applied because it was not legible.
We'll take a break and come back.
Yes, sir.
In the meantime, you see the trial court record.
Yes, Lord.
We might have page 57, my lord, though it is not at page 57, the 1951 NRC, my lord. Her father's name also, page 57.
57 was discarded being a photocopy. And what is this document, page 59? This is not an exhibited document.
Page 59, no, this document would not. And this document and my annex 10, these two land document was not exhibited, not omitted.
No, but if you have an additional document, why you did not prefer a review? And came to the High Court, because High Court under 226 cannot look
Yes.
into a document which is not a part of the records of the tribunal.
My lord, because my lord, there is a limitation, my lord, in the limitation cannot be found on.
Huh?
Lordship.
What do you say?
Lordship.
You have gone through the records.
Yes, Lordship.
What do you say?
Lordship, my only submission is that Lordship, we cannot go beyond the record, Lordship. As Lordship para 112 of the Muslim Mandal case, Lordship specifically stated that, may I read Lordship para 112? Lordship, Article 226 of the Constitution confers on the High Court's power to issue appropriate writ to any person or authority within the territorial jurisdiction. The tribunal constituted under the 1946 Act, read with 1964 order, as noticed above, is required to discharge the quasi-judicial function
The High Court therefore has the power under Article 226 of the Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. The scope of interference with the tribunal's order in exercise of the jurisdiction under Article 226, however, is limited. The writ of certiorari can be issued for correcting the errors of jurisdiction as and when the inferior court or tribunal acts without jurisdiction or in excess of it or fails to exercise it, or if such court or tribunal acts illegally in exercise of its undoubted jurisdiction, or when it decides without giving an opportunity to the parties to be heard or violates the principle of natural justice. The certiorari jurisdiction of the writ court being supervisory and not appellate jurisdiction, the court cannot review the finding of facts reached by the inferior court or tribunal. There is, however, an exception to the said general proposition in as much as the writ of certiorari can be issued and the decision of a tribunal on a finding of fact can be interfered with if in recording such a finding the tribunal has acted on evidence which is legally inadmissible or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all, because in such cases such error would amount to an error of law apparent on the face of the record. The other errors of fact, however grave it may be, cannot be corrected by writ court. As noticed above, the judicial review of the order passed by the inferior court or the tribunal in exercise of the jurisdiction under Article 226 of the Constitution is limited to the correction of the errors apparent on the face of the record, which also takes within its whole a case where a statutory authority exercising its discretionary jurisdiction did not take into consideration a relevant fact or renders its decision on wholly irrelevant factors. Hence, the failure of taking into account the relevant facts or consideration of irrelevant factors which has a bearing on the decision of the inferior court or tribunal can be a ground for interference of the court or tribunal's decision in exercise of the jurisdiction by the High Court. Then, Lordships, Lordship, I am telling tribunal has uh, pass the order on the basis of materials available on record, Lordship. And another submission is that, Lordship, Proceedy has already getting the benefit of this order, Lordship, by registering his name, Lordship, as mentioned in writ petition, Lordship.
Yes, it's Annex 29.
You have registered already.
Yes.
So then.
But then if you have registered this, no purpose of taking up the matter or deciding the opinion.
You complied with it.
My lord, genuinely, he is a citizen of India by birth, my lord. But by registering, my lord, she has been deprived 10 years, my lord.
But you had registered already.
Yes.
That cannot be undone. There is no provision by virtue of which the registration once effected can be undone.
We interfere with the opinion. What happens to the registration you have undertaken?
If my lord, the tribunal recall his, order, my lord, then subsequent things. will
There
go.
has to be a direction. Prior to a direction, there must be a prayer. You don't even have a prayer here. You have not even put to, because you have registered, therefore you have not challenged it. Once you register, you're complying with the opinion, with the findings. And this was done in 2018. Subsequently, writ was filed.
As per instruction of the, my lord, the guest council, she registered. my lord.
Petition is of 2020 after registration. And once you are not challenging that, the other questions are academic. Accepted challenge cannot be made.
Hmm?
The accepted challenge cannot be made. Close for the-
They were pointed out. One order. There's only one order.
Where is the document of registration?
My lord, page 29,
Page
29,
20,
29.
29. Heard Mr. S.K. Roy, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the Home Department, representing respondent numbers. You first you say what CEC. CEC was here. Ms. L. Devi, learned counsel appearing on behalf of Mr. R.K.D. Chaudhary, learned DSGI, representing respondent number 1. Mr. G. Sharma, standing counsel for the Home Department, representing respondent numbers 2,
7 and 8.
numbers 7 and 8. Sir, the R.K.D. Chaudhary will also be for 1 and 4.
Yes, Lordship.
Then Mr.
H.
H. Kuli, learned counsel appearing on behalf of Mr. A.I. Ali, standing counsel for the Election Commission of India.
Your lordship, my lord, give me one chance, may I take a chance to search the law on that issue, my lord?
No, see, there is an opinion
Yes.
holding that you had entered, you are a foreigner between 66 and prior to 25th March. And you have gone and registered.
But I remember, my lord, I've seen a judgment, my lord, even an order, my lord, if I comply, take the benefit of that order, my lord, then also I can, my lord,
Why don't you make up your mind? We have heard you, and this issue you should have placed it on the first time. Don't make submissions unless you are prepared to argue the matter. We have heard you for almost an hour now.
You see, we want to take an adjournment, take it in the first blush, but after we apply our mind, then it's not very fair.
Lead up over. They really number one. Why they
No.
order to lead up. Declare is taken registration.
But then you say both sides are represented. Don't write all this then. Huh? Both sides are represented. On the court query, whereas the petitioner has already registered herself before the FRRO Dhubri in compliance of the opinion dated 8/3/2018 passed by the Learned Foreigners Tribunal 8th Dhubri. Whether any live issue remains to be examined, the Learned Counsel for the petitioner prays for an granted adjournment to address the court. List after a week on a date to be fixed by the office. Published.
Item 13.
My lord, I may be given 1 week time, but I could not go through the records.
All sides are represented. On the prayer made by Mr. A.R. Siddhar, Learned Counsel for the recession. List after
After a week, my lord.
after a week.
Fourteen.
Lordship, as per instruction, the writ petitioner had expired. Kindly
Expired.
had expired. Kindly.
You are a counsel on record?
Yes.
Are you a
yes, sir.
counsel on
Yes,
record?
Your Lordship.
Okay.
Lordship will be allowed a date to submit a death certificate. To
Okay.
submit a death certificate.
Okay. Your name?
Miss A. Hussain.
Miss A.
Hussain.
Miss A. Hussain, Learned Counsel for the petitioner, upon instructions, has submitted that the petitioner has expired. He prays for some time to
21 to dear.
bring the death certificate on record. Matter stands adjourned today. Next, all the respondents are represented. List after
Any date may be given. Any date may be given. Any date may be given.
no. How much time do you need to produce this document? Date I can give tomorrow also, but are you prepared?
Lordship, then 4 weeks time may be given.
Okay, list after 4 weeks.
Obliged.
Item 21, supply for admission.
Make it your lodge.
Yes.
Yes, my lord. My lord, in this case,
I have gone through the Bhutan list, my lord. Some confusion was there, my lord, as earlier lordship noted, my lord. So for my lord, 1993 Bhutan list, lordship may kindly see page 55, my lord.
Nineteen
93, my lord.
93.
Yes, my lord.
Which page?
Uh, Page 55, my lord.
65.
55,
55.
Yes, my lord. My lord, This Bhutan list relating to the village Bedouhati, my lord. Is the parental house of the petitioner, my lord.
Your father, mom, relatives of now.
What is the name of your father?
Abdul Rashid, my lord.
Abdul Rashid.
Yes, my lord. And Sophia, my lord, my mother, then one brother, my lord, the three-year brother, my lord.
Adil Hamid and Latif.
Yes, ma'am. Nothing.
They are
They are brothers.
brothers.
Yes, ma'am. Lakshmi, may kindly see another brutalist, my lord, page 57. Some discrepancy in the name, my lord.
Yes.
My lord, Sarafatullah, father-in-law. This is the village relating to her, my lord, the husband, my lord. Erakopli.
Your name is Zaida Khatun.
Jaida Khatun, my lord. Here, my lord, Lakshmi, may kindly see Afia Khatun, her mother-in-law, Abdul Latif, brother-in-law, Monwara Khatun, my lord, wife of Abdul Latif, and Abdul Matin, husband of the petitioner, my lord. And then Jaida Khatun, my lord. It is written wife of Abdul Latif, my lord. This is wrongly written, my lord. And somewhere I have, my lord, mentioned in my evidence in chief, my lord. And thereafter, brother-in-law, my lord, Abdul Kashem, Abdul Hasem, my lord. And thereafter also Bhutanese, my lord, it is correctly mentioned, my lord. Lakshmi, may kindly see page 59. Is, my lord, due to some name of the village change, my lord. But husband name is there, Abdul Mateen, Jaida Khatun, wife of Abdul Mateen, my lord. And from 1966, my lord, her father name appeared in the voter list of village Bedouhati, my lord. Milord.
Yes. Mm. 75. No, last time we adjourned the matter on a different query.
My lord, linkage document, two linkage document, my lord. One is Gaubra certificate, another is, my lord,
School certificate.
School head.
If both goes, then there is no link
My lord,
certificate.
My lord, I have gone through the record, my lord. In page 82, lordship, my lord, one document is there, my lord, school, my lord, the leaf of the register, my lord.
But
Lordship,
that is
kindly-
not exhibited, it is, we have searched this thoroughly.
Lordship.
In the trial court record, there is no petition to accept this as a evidence.
Lordship.
There is no document.
Lordship, I have also gone through the, my lord, these honorable courts, some order, my lord. Almost similar fact and circumstances, lordship. These honorable court, my lord, remanded the matter. Here also, my lord, one Gaubra certificate is there and one school certificate, my lord. And brother also examined, my lord.
You see this page 82 he is referring to from the trial court records. Just go to it. No, 82 the trial court records.
Yes.
Which paragraph in this? So then,
Lordship, if a relevant one, there are 3, 9, 15, 19, 34, 38, 39, 40.
slow, we are not that fast.
Lordship,
Paragraph
paragraph 3, 9,
3,
yes, madam, 9,
9,
15, 19,
16, 16,
madam, 19,
19,
19, 34,
34,
38,
just 38,
39,
yes,
madam, 40,
40,
yes, 53,
53,
54, and my lord, 58 to 64.
58
264, my lord.
It was 64.
Yes.
But this doesn't help you. This doesn't, this judgment doesn't help you. Now you see, come to paragraph 40, which you are relying on.
Lordship.
However, in the present case, neither the author of the certificate was examined nor the contents of the certificate were proved with reference to the school records. Correct?
Lordship.
Now, now you see, come to paragraph 49. Last line.
Lordship.
It may also be mentioned that the was a Gaubra was aged citizen deposed by so and so. Discussed in new so that it was not cross-examined in any aspect, more particularly as regards the name of the mother. Correct.
Yes, Lordship.
But other things were matching. Paragraph 50 will show that other things were matching. The
Yes.
documents were matching. Now come to 53.
Lordship.
The tribunal also observed that a forged copy of so and so was proved in original. Thus, having seen the original document, the learned tribunal could not dispute on the ground that the petitioner did not remember the headmaster. These things are not there in your case.
My lord.
Para 54, 30-year-old document.
Yes, my lord.
Paragraph 56. Although the certified copy of the, although the uncertified copy of the voters list was presented, but the original records were called for.
But in my case, my lord, headmaster was examined, my lord, but and this Gaubra also examined, my lord. But
But
they
if
have
this document goes, if the document
So-
goes, there is no link.
if
That
one
is
of
the only
Well,
question we were asking.
it is, my lord, not that she did not produce, my lord, she produced, but due to my lord,
And the distinguishing fact in this case is paragraph 57.
Lordship.
Thus, in our view, the general observation made by the learned tribunal that most of the documents were collected by the petitioner during the pendency of the evidence, and some were not proved by producing attested public issuing authorities cannot be good ground to ignore the said documents. So those documents were there.
Right.
And not in evidence, but in this
In
record.
my case, my lord, all voter lists are there, my lord. All the certified copies. My lord,
Lordship,
people are to allow
voters
me.
list, if he goes by that, then there's lot of discrepancy, Lordship. And there's two main documents, the linkage document, school certificate and the Gaubra certificate. Both are not admissible because one is because of the stamping, Lordship, and one was only for the purpose of NRC, the Gaubra certificate. And the school certificate, transfer certificate, Lordship, that has the state emblem on it.
No, just, we're just thinking aloud. You see, yesterday evening, I gave a certificate to one of the law students who was there attached to me. He was there for 2 weeks. I gave him a certificate. So-and-so, son of so-and-so, age so-and-so was placed under me for the purpose of this so-and-so, and I wish him well in life. So that is the standard given. And now, last line was that This is only to certify that he has attended the court proceedings, correct? Now, the purpose is very clear that he is a trainee and therefore he is getting a certificate. But whether the merely because a purpose is given in that document, will it erase the otherwise the contents of a document for any purpose?
Lordship, for NRC, it was specific because at that point of time, the family tree was made. It was a very scientific method to bring in people from the family lordship. Otherwise, what happened during the practical time when these people had to go and meet in the Seva Kendra's lordship? For one person, 200 people came who claimed that that person was his father. But when they reached the Seva Kendra, they knew that nobody knew each other. So for that purpose, only this document was issued so that the married women could state that so-and-so was her father. For no other purpose, Lordship. It was only for the benefit of the family tree to prove that the names of the right people are incorporated in the NRC.
No, but you see, once a document, you make it admissible for the purpose of NRC, the contents of the document cannot be relevant for any other purpose. Because if you give a citizenship on the basis of that document, how will the contents of that
was
document be?
only to prove that so-and-so is the daughter of so-and-so, Lordship. Not even the husband is names matters there. And they are also relying on that document, only the two documents where the father's name appears after marriages, Kabin Nama and this NRC certificate. Birth certificate, none of them have. So even the government had this problem. So they came up with the idea of the family tree. When the family tree was drawn up, Lordship, and these documents, every person had to fill in a very elaborate forms. If Lordship remembers, even we had to do it. But when their names mismatched and did not reach, they put in their complaints with the Seva Kendras, they came there. And most of the people didn't know each other. And there they did not have this aliases, this one person having 4 aliases or 5 aliases. Here, if Lordship sees, the opinion will have one name, but when the writ petition comes, there are 4 or 5 names. They're trying to link with every document a different name, and that name comes up as their license. Lordship, another thing which I have noticed in this Lordship, 89, the petitioner's name appears for the first time in the same village as her father's village. And here she is wife of some Ang Latif. Today, yesterday, the last time when this hearing had come up, we had noticed this.
Yes.
And here, the name of her husband also, whom he is referring to today as her husband, his name is also there. And then Lordship, at page 57, the husband's name and the wife's name is there. And the village has changed here. So that means the first time the wife's name came up, it was in her father's village, not in a different village. And there's no continuity also with that.
Complete.
At page 59, now after the 1993 document, the next voters list is at of 2016. Here everything is in order. The earlier documents, Lordship will notice 66, 70, 87. In between, there is no continuity. Slowly, when the documents are, it takes time to put them in order. And after some time, Lordship will see everything is in order. And this is what has happened here also. Page 53 and 57, if Lordship will look into page 53 and 57.
In
66.
53, some typographical mistake is there. 53. This
it is
village
so?
is,
53.
yes, my lord. Erakopili. Village
No,
is-
just a moment. Let
Yes.
Verma complete.
So that means she was married in her own village. Later on, she shifted to a different village. Because the village same remains, even if the name is wrong, Lordship.
No,
Her-
no, 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 wrong is typing.
No, village or name wrong hoise
No,
ki.
no, typing wrong.
Yate ko basi.
53 to typing wrong also. Original to some Erakopili.
After 2016, Lordship will find everything in order. By that time, considerable time has gone, all documents have been procured. And then again to prove the citizenship that about the father, because the father is nowhere to be found in all the earlier voters list, Lordship. Then comes the Gaon Panchayat certificate. And then comes the Kabirnama. These are two most important documents. And if these two documents he is not able to prove, Lordship, then he has no linkage and he has got no case also.
We'll take it up next week because
Yes,
today the
sir.
bench is no longer.
I have some judgment of the
Yeah.
Supreme Court also. Madam. I have some judgment of honorable.
No. Sorry, those things we are not adjourning. You see, it's a bad habit to
No,
let
my
the
lord, I'm-
argument begin and then
but
say
I-
that I have one more document, judgment, one more thing.
No, my
This
lord,
thing
due to
must stop.
paucity of time, I can. give-
These things must stop. Whatever you have, you complete your part, then we hear the other side.
I have those judgment, my lord.
For each and every submission, you can't be permitted to give a response. What is it? We do possibly time matter could not be taken up today. List on 21, 8/2024. List after week. List after week, all 3 matters. Other matters, 3 matters are left after a week.
All right.
It's regarding item number 12. Now we'll have to file an impeding petition, my lord, impeding the new income. So, my lord, at least 1 week time may be granted, my lord.
Okay. To impede the new incumbents.
New incumbents.
Okay. On the prayer made by Mr. PJ, Learned Counsel for the petitioner. List after?
After 1 week, my lord.
List after a week, so as to enable him to file an application for impeding.
My lord. And I have already taken consent from the others.
So this Monmouth is represented.
Okay, go good. Most of.
May I please your lordship? My lord, today I have some personal difficulties in second half, my lord. So may I play item number 20? It may be taken up another day, my lord. Because it is a review matter, so tied up matter.
Okay, you're there. Okay, both sides are represented on the prayer made by Mr. S.K. Ghosh, counsel for the petitioner. List after
Next,
a week.
Insofar as
Yes.
item number 25 is concerned, that's a review matter, my lord. It's a joint review. Could it be on next Tuesday? It's on a very small issue though. It'll be on Tuesday, my lord.
Because the determination is changed. Now we are taking up this, what you call, I'm taking up the division bench.
Oh,
So
then it will
therefore,
be. Otherwise, we'll not get the bench again.
have next when it is considered, we don't know.
But Monday, Tuesday,
You said
Perhaps-
list it after a week. In the meantime, we
in
just
the meantime.
examine.
then let it be there, my lord. Otherwise, if we don't get the bench, it will be difficult because it's a review petition. Adjournment may be costlier then. We'll wait.
Yes, because
I understand.
May I please, your lordship? My lord, I beg to mention item number 18.
18.
18, my lord. My lord, the grievance of the petitioner has been redressed. The grievance of the petitioner has been
Redressed. Okay. Mr.
F.L. Oscar.
F. A. Laskar, Lord Counsel for the petitioner. Upon instructions, I submitted that the grievance of the petitioner has been redressed. And accordingly, his instructions not to press the matter. Mr. Standing counsel for the SCERT is present. Matter since closed on satisfaction.
Obliged.
May I please, your lordship? My lord, I recommend item number 4, my lord. In this contempt petition, my lord, I shall have to include the new incumbent as a contemptor, my lord. So 2 weeks time may kind of be allowed, my lord.
Same item, PG again, same PG program. Mr. T.U. Laskar for the petitioner. For including 2 weeks.
Highly honored.
Both is at present.
Between item number 10 is a contempt petition. Some developments are there, Lordship. Therefore, Lordship may grant one week time. Lordship, I have to file an implement also for the new. Otherwise, if it is his grievances are redressed, Lordship, I can.
Usually, both sides are represented. On the prayer made by Mr. B.P. Bora, counsel for the petitioner, list after a week.
Daily list item 1, motion BA.
May it please, your lordship. This is an application under section 483 of the BNSS, my lord. The
This
FIR,
was earlier rejected by this bench.
no, my lord. Whatever, my lord, the some co-accused has been granted bail by your lordship. That's why the matter has come up before your lordship. But here in this case, the present
It was in
petition,
which matter?
my lord,
Bail was granted in which matter?
my lord, in the same matter, my lord, bail petition is at page 36, my lord.
6.
Yes. Two order has been passed and released bail to accused petition, accused my lord. 36 and 40.
Okay, list along with the both sides are represented. List along with the records of BA 1648/2024.
And 2006
and
2006 2024.
2006 of 2024. You need the case diary?
Lordship.
My lord,
How much time?
Lordship, fix it on 30th of August
30.
30.
Okay.
in fact, the
Next,
petitioner
meanwhile,
behind
with the case diary be produced on the next date of listing, expire list on 3/08/2024. Yes, you were saying something?
my lord, this petitioner behind the bar since 6/6/2024, my lord. And in this case, my lord, he was shown arrest.
From 27.
What had happened, my lord?
But without case diary, we can't
326.
examine the matter. Since you are pressing for the bail on the ground that the co-accused has been released, let us see Here what has happened? Case diary as well as the previous criminal antecedents of the petitioner. Today is 16th.
Yes.
Can you expedite it?
Try him, that's why, my lord.
It is from South Salmara Lodge.
Can it be 26, 24?
28th, not wait.
Much of this.
Item 2.
Yes, Mr.
May I please lost.
Yes, Mr. Ali.
Page,
Rejected earlier by this bench.
page 26, my lord.
26. Mr. Goswami, you can release him now.
Today is 76.
11/7/24
Lord,
was the last rejection on the ground that he has suffered
Injury.
injuries. He was arrested when?
my lord, he was forwarded on 2/6, my lord, to the 76.
2/6. Today is
76 days.
76 days. But Mr. R. Ali, learned counsel for the petitioner, as well as Mr. Goswami, learned APP for the state. So this is the second application for bail under section. And before this court, under section 483 of the BNSS, 2023. In connection with dispute PS case number 539 of 2024, under section 341, 326, 307 IPC. First, the previous application for bail being BA 1763 of 2024 was rejected by this court by order dated 11/7/2024. Next one. The learned APP has opposed the prayer for bail on the ground that the petitioner has grievously injured a young female and has caused the following injuries. Page 27. Next one. But what is the condition? Can you find out?
Lordship,
She's alive or she's dead?
No, like she, after a few days, she was released. When my lordship rejected my prayer, my lord, before that she was released.
You made a
Lord.
statement anywhere?
Well, lordship,
Have you made a statement anywhere whether she's alive or not?
my lord, I have made statement on paragraph 7.
7.
Lost. The last part, my friend.
From the contents of the FIR, it appears that the petitioner has attacked the victim with a sharp weapon and caused grievous injuries on her, and she was admitted to a private hospital at Guwahati in a critical condition in the ICU. Full stop. In this regard, the learned counsel for the petitioner has referred to the statement made in paragraph 7 of this bail application and has submitted that in the meanwhile, the victim has already been released from the hospital. Full stop. Next, but it is also noted that on a perusal of the case diary, the prayer for bail of the petitioner was rejected by order dated 11/7/2024 in BA 1763 of 2024 by recording the nature of injuries sustained by the victim. Next, however, on a consideration that the petitioner was arrested and remanded to custody on 2/6/2024 and has spent 76 days in custody. Considering the length of detention, the petitioner is inclined to release the petitioner, namely so and so, on bail, on furnishing a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the Chief Judicial Magistrate, Kanpur Metro Guwahati. First one, bail is granted on the following conditions. He'll appear before the IO once a month till his personal appearance is dispensed with or charge sheet is submitted. Next paragraph. As a condition of bail, it is provided that if the petitioner makes any attempt to meet and threaten the victim or any of the family members, it will be open to the investigating officer to move the jurisdictional court for cancellation of bail. Court bail application stands disposed of.
Item 3 for motion.
Item three, same as out of same FIR Lordship, South Sharma, earlier one, item on number one.
Same.
So fixed date is
Same.
20.
Your Lordship, this is anticipated
Case
bail
diary-
application, Your Lordship. Anticipated
AB.
bail application, AB.
Let the case diary be produced on 28/8/2024.
Your Lordship, interim regarding one woman, Your Lordship.
Pardon me?
Interim regarding one women accused, Your Lordship. Accused number 1. Accused number, FIR name accused number 21. She is an Anganwadi worker, Your Lordship. Having minor children. Your Lordship, para 3, page 4. This is my prayer, Your Lordship.
No, what your involvement is there,
Lordship. The appraisal of the case, right, Lordship, then
The involvement appears to be there. You're accused number 21.
21.
There's an allegation that the police personnel were attacked.
Lordship. He was fallen unconscious, Lordship.
Let us see the case diary.
Lordship.
Case diary also.
28. Lordship. Obligation.
Item 5.
Contempt petition, my lord. The state, my lord, file review, my lord. And review was closed on the basis of that during the pendency of this contempt petition as well as review. My lord, petitioner is already appointed as a tutor.
Okay,
that
so this will be closed.
On the basis of that.
Okay.
This is the review of the lordship part of it. And liberty may be given if necessary.
No, if it is, if he is already appointed, there is no liberty. Because in contempt, there can't be a liberty.
No, they can be challenged that because the past
No, no.
service
In-
that issue. my lord.
In contempt, there cannot be a liberty.
No,
because
contempt cannot. Yes,
There cannot be a liberty.
Normal. Contempt cannot. My lord.
Mr. N. Boran, the only counsel for the petitioner, upon instructions, has submitted that this contempt petition arises out of non-compliance of the order dated 13/8/2015 passed by this court in WPC 4085/2012. Full stop. It is submitted that the state had preferred a review petition against the said order, which was registered and numbered as review petition number 43/2016. And this court by order dated 24/3/2023 had closed this said review petition as infructuous on the ground that during the pendency of the review petition, the petitioners herein had already been appointed as tutors, however, without claim to their past service. Full stop. Full stop. In this regard, the learned counsel for the petitioner has produced the copy of order dated 24/3/2023 passed by this court in review petition 43/2016. Full stop. Taking note of the fact that the petitioners have been appointed as tutors, the court is of the considered opinion that although belatedly, but the order of the court has been complied with. So accordingly, this contempt petition stands closed.
Absolutely.
The copy is already on record.
Mine. Your lordship, as your lordship say on instruction, that instruction may be matter deleted, my lord.
Hmm?
Your lordship says that on instruction, my lord, client has no relation with me, my lord. So, on not instruction.
Or not instructions. Has nothing, not instructions.
Absolutely.
Item 6.
May I be lots? Yes, started seeing after a long time. That's it.
Is 17 lots of the judgment passed on 14/5/15.
Just a moment. Education, somebody is there? Nobody is there in education? This is of which department? Elementary. You are there for elementary,
No, your lordship.
but somebody must come for elementary department because this is a long checkered history in this petition. Contempt of order passed in 2010. Item number, this is item 6.
Lordship may take up to some time, your lordship.
Is give us call for respondents council in item 6. Don't give names, there are a lot of people.
Item 7.
Ask somebody to be there if you can,
Yes, your lordship.
because we have to know the developments after that. After this
Lordship,
contempt petition,
they
there
were
were
initially
series of
appointed-
petitions.
Sorry, Lord. Initially appointed as a estimated teacher. Already our Honorable High Court has passed so far estimated teacher is concerned. Subsequently, they were made supernumerary teacher. There also, this Honorable Court has passed order, madam. So, madam, in a calculated manner,
But you
madam,
got the benefit, you were appointed.
Lordship,
Have you been appointed?
no, madam.
You're not appointed. I think you were appointed, but not as
Yes, I'm appointed madam by initially estimated teacher, later subsequently supernumerary teacher.
so then what remains here?
Just to regularize my lord.
For regularization, there can't be contempt. But for regularization, there can't be contempt. You have to seek remedy in a writ petition.
Madam, my a simple prayer, my lord, whatever the order passed on 2015, that must be complied with, lordship.
Which page is that order?
That is, my lord, page 17, lordship,
17.
17, my lord. Relevant portion, my lord, that bottom, my lord, in view of the above, all the writ petition are disposed of with the following directions, my lord. The petitioner should be provided with, may read, lordship. As regard the claim of the petition that the sum of the similarly situated teachers are in receipt of the monthly salary in the time scale of pay from the date of regularization of their service. The case of the petitioner shall be examined at par with the similarly situated teachers, if any, about whom the petitioners have referred to their petitioners. Let the required exercise towards compliance of the order be carried out expeditiously as far as possible, preferably within 3 months. As the petitioner are similarly situated, the
But
respondent authorities are
let us see your appointment order.
directed to the,
Let us see your appointment order. Where is that?
that is, my lord, maybe in WPC, my lord, not in the contempt petition.
No, because somewhere I read in this file
Proceed.
that your appointments were not irregular appointments. So therefore, this for the purpose of compliance, the case of Uma Devi comes in the way.
They were, lordship, initially estimated teacher. Subsequently, Goff created supernumerary post. They have created, my lord.
Whether it is stipended teacher or not, but the regular process of appointment was not being followed. So therefore, somewhere I have read in this file, I can't track out where.
My
It has
lord,
been mentioned that the
have
appointment
been
was not a irregular appointment, and therefore question of regularization will not come.
my
But
lord,
that is the law. Then where is the contempt?
no, my lord, that was not irregular appointment, my lord, regular appointment, my lord. Similarly situated person already regularized, my lord. That is my prayer, my lord.
Pardon
And
me?
subsequently, my lord, Goff has created There are unsaid minor, supernumerary post, my lord.
So supernumerary post is, you see, it's outside the cadre.
Lordship.
Supernumerary post is outside the cadre. And you have been given this, what you call, your appointments are there.
And supernumerary also.
Just show me the appointment order if you have a copy.
Their initial grievance was, Lordship, they were not sent for training, my lord.
So whatever be, but once you say that you have been appointed, where is the appointment order?
Order, my lord, maybe
You have a
the
copy?
WPC that maybe record maybe call from, my lord.
It be available where? In the writ petition? No, it will not be there in the writ petition. The writ petition has already been disposed of
My
long
lord,
back.
I'm
It is
here only for that judgment passed on 2015, my lord. And that person already argued, my lord. After hearing both the parties, this order was passed, my lord. It is my humble prayer with your lordship.
No, you see, one part is that what you are saying, correct? But where is the affidavit? We don't know.
And that apart, my lord, if somebody is agreed, my lord, if they are agreed, my lord, they can prefer appeal review at chief, my lord. Last 8 years, my lord, they didn't hear anything, my lord. Then attend finality, my lord. And finality has to be applied in strict manner, my lord. It is settled law, my lord.
You see, that's why we are asking for that appointment order. Then we'll come to know whether there's been a contempt or not. And where is the screening committee report? Just wait for some time. Unless if the respondents are not there, we'll ask for personal appearance. Just wait for some time.
Or maybe after a week,
Huh?
lordship.
Huh?
Maybe after a week. If convenient.
No, adjournment is not inconvenient. That can be granted at any point of time.
No, but sorry. For my partner, some difficulty, my lord. Otherwise, I'm here, lordship.
No, either you are ready or you are not ready.
I'm ready, my sir.
I'll just wait for some time then. Let the respondents come, then we'll
Lordship.
examine. Just wait for some time.
Lordship.
Item 7.
The order against which this contempt application has been filed, my lord, the state has preferred an appeal. Now that appeal is listed today before the Honorable Division Bench as a part heard matter. So I will request your lordship to post this matter after 2 weeks.
Okay. Mr. P. Bharadwaj, learned counsel for the petitioners, has fairly submitted that against the order in reference, non-compliance of which the present contempt petition is filed, has been assailed by the state in an intra-court appeal, which is listed before the division bench of this court today. Accordingly, pays for an adjournment. You're there?
Yes, sir.
Mr.
For respondent number 5.
Das Limit, counsel for respondent number 5 is present. Stop. Accordingly, matter stands adjourned today, list after 2 weeks on a date to be fixed by the office. Mr. Das?
Yes, Your Lord.
In fact, yesterday I came to know senior Mr. Das has injured.
Yes, Your Lord. He has a broken bone on the right leg, Your Lord.
How is he now?
He is recovering, Your Lord.
Okay, I'm sorry, yesterday I came to know.
I pay for respondent number 2, my lord, in this case.
Okay, Mr. BB, Mr.
B.
B. Gogoi
Gogoi.
for respondent number 2.
Item 8.
May I please, Your Lordship? Lordship, I'm appearing on behalf of review petitioner, Council N. Talukdar. He is suddenly he fell unwell and he has to go back to his home. So this is, I'm appearing on his behalf. And to let the honorable court that as per the last order, the steps has been taken. But unfortunately, he is unable to appear.
No, the office note says it has been returned. The petitioner and the. You're for respondent 1?
Yes, my lord.
And the respondent number 1 are represented. As per office note dated 25/6/2024, unserved notice upon respondent number 3 has been received back with postal remark, inverted commas, left, comma, return to sender, inverted comma, closed. Postal. The petitioner shall take note of the same and ascertain the correct postal address of respondent number 3. And bring it to record in an appropriate manner. Please go. How much we give you 1 week's time? Just after a week. Bring it on record, the correct address.
Item 9.
May I please, Your Lordship? Steps has been taken today.
Has been taken.
Yes, my lord.
Office note says you have not taken steps.
No, today, my lord, we have taken. Today it was taken, my lord.
Oh, today taking steps will not help you. You have to take first steps again. If you take steps today for a notice issued on 2019.
I apologize for that.
No. Don't tell us that. The counsel for the petitioner is directed to take first steps for service of notice on the respondents. In this case, there's no point issuing a notice on the respondents. At least out of the people I have heard of, the names I have heard, none of them appear to be here. In 2019 contempt, these people will not be here. You are referring to the first name I have seen is Alok Kumar, Chief Secretary. Is he the Chief Secretary today?
I'm not actually, I came on behalf of my senior man.
No, whoever you come, you must know the name of the Chief Secretary of
No,
the
he's
state.
not right now, he's not the chief secretary.
Then, if you have taken steps, what good you have done? As per the counsel for the petitioner is present and submits that steps has been taken today. Next one. What takes note of the fact that perhaps most of the respondents are no longer holding the posts against which their names are reflected. First off, the petitioner shall ascertain the actual place of posting of the respondents and bring it on record by in an appropriate manner. List after 2 weeks.
Publish, my lord.
Item 11,
Yes, no representation from the petitioner or the respondents. As per office note dated 27/2024, petitioner has not taken steps for implement. And just as the matter stands adjourned today, list after 2 weeks.
13,
My lord, the order has been complied with, my lord.
Is it?
Yes, my lord. It is complete.
You have the information?
No, Lordship.
Okay.
Instruction, my.
Yes,
D. Datta. D. Datta.
D. Datta, learned counsel for the petitioner is present. Next. Mr. D.P. Bora, learned counsel for the respondents, has produced a photocopy of an order number HSF/PH/122/2019/9889 dated 24/6/2021, by which the petitioner has been appointed. First of number. Next, the learned counsel for the petitioner expresses ignorance of the same. First of matter stands adjourned for 2 weeks to enable the to obtain instructions. You take this copy. We have a copy here.
Yes,
We have a copy here.
yes, my lord. Yes, last occasion it was.
Yes, yes. List after 2 weeks. On a date to be fixed by the office.
item 14,
All the order of the, in this case, comply.
Complied.
Yes. Maybe
Your name?
K. Kolita.
A. Kalita.
K. Kolita.
K.
Yeah.
Mr. K. Kalita, learned counsel. Appearing on behalf of the counsel of record for the petitioner, has submitted that as per instructions received, the order of the court has been complied with. And he has instructions not to press the matter. So according to this, contempt petition stands closed on satisfaction.
item 15,
Yes,
The last occasion, Lordship, the extending council, division department take times to for inspection, Lordship.
I'm not hearing you. Please speak again.
The last occasion, Lordship, the state council has taken time for instruction, Lordship. On the Lordship. 8/5. 8/5/2023, Lordship. After a long time, Lordship. It is mistake.
Education, somebody is there? Mr. Chismi, you are there. We just wanted to get a, you're not there in the matter.
Yes,
We just wanted some information from you. Just see this file.
Yes.
It.
Yes.
We'll take it up after some time. Let him get the file.
Yes.
Item 16.
16, Lordship, I beg your Lordship's apology. Here, what happened on the last occasion, we came to know that the present incumbent has already left the office. There was some other incumbent. So we're required to submit a representation. I advised accordingly to my client. But I don't know thereafter what happened. Might be they have been transferred in different places. They did not turn out, Lordship, to me. So the representation
adjourn the
could not be
matter.
filed.
We adjourn the
I'm
matter
praying
for
for
2
some
weeks.
time, Lordship.
We adjourn the matter for 2 weeks.
Yes, Lordship, I'm praying for some time.
On the prayer made by Mr. Bhattacharya and counsel for the petitioner, list after 2 weeks.
Deeply appreciated.
Mr. Sisi, in the education department, we are also wanting you for this matter of in this item 6. Officer Arnett.
I question.
Oh.
Appointment, WBC next for also.
Okay. It okay. Lordship, I'll let to Lordship fix it. Lordship will take it up today itself, or Lordship has given some.
No. So far as I am concerned, I am ready with every matter. Whether it's now it is on you. Whether you want to take it up or not, do it or not.
I will no. Lordship may kindly give me some time to go through these lawsuits. Armudundar, you are supposed to appear lawsuit. I think he has some difficulties today.
Okay. Mr. Ahmed, so God had heard you.
My
When-
humble summons your Lordship, my lord. So for content is concerned, my lord, there cannot be any actions of pleading or any argument to ascertain the order already passed. If somebody is agreed,
That's okay,
take it up,
but
my lord.
let him go through it. He wants some time.
So, my lord,
When?
if you Lordship want to see the appointment letter, my lord, all the appointment letter is establishment distance, my lord, and the record may be called for, my lord. All the teachers appointed initially, my lord, as establishment teachers. All the teachers, all the
No,
teachers.
we do
Whatever
two
legal
things,
guidelines.
because you see, I have a bad habit of digressing here and there.
No, Lordship, no.
So that is one.
I'm
The
not on that. I'm
second
not-
part is that unless we look at the appointment orders, how far there has been a contempt, we don't know.
Lordship.
So that's the main issue. It's not for any other inquiry, but to know how far the contempt is made out.
My lord, in a calculated manner, they undermine the judicial pronouncement, Lordship. So for WPC concerned, they 5 years never file any reply, my lord.
No, that's okay. Let them hit, have it, please, then we'll apply a mind.
Lordship, then,
When?
and in the meantime, my Lordship, may call
Both
for
of you
the.
agree to a date. Mrs. Chisti, with consultation with Mr. Ahmed, fix a date.
Next week, any date, after Thursday, Manoj.
Next week, any date.
Okay.
Lord, I'll get the instruction, Lordship, on today, as you will, he take, no?
Okay.
16.
Both
Date
sides
of-
presented
On
prayer-
28 Lordships, holidays are there, 28 Lordships.
On the prayer made by Mr. SMT Chisti on council for the respondents.
20.
List on 28, 8/2025. Okay.
মোক খালি কপিটো মোৰো নাই ন এটা একটু
Item 17.
Lordship, oblige.
17.
Lordship, may I please, your Lordship? Order is complied, Lordship.
yes here it is compare
Okay. Your name?
MK name, Lordship.
Upon instructions, Mr. NK Neo, learned counsel for the petitioner has submitted that as per instructions received by him, the order of the court has been complied with. Mr. B. Talukdar, counsel for respondent number 1, endorses the said submission, which is also recorded in the order dated 19/4/2023. Next one. Accordingly, the matter stands closed on satisfaction.
Item 19.
Right, please.
In this case, Lordship had granted the liberty to refile the appeal, which was originally filed as a second appeal under section 100. It was wrongly filed under section 100. It should have been filed under order 43(1) U, because it was an appeal against an order of remand, first appellate court. In the meantime, what happened was that Lordship had allowed 2 weeks time. Then the COVID period kicked in. The time expired, and further, the order is also not clear in the aspect of court fees. The limited prayer is that the period may be extended 2 weeks time from the date of the return of the appeal memo and the court fees. So we can refile. Earlier, my lord, we were allowed to correct by way of hand. Whether it will be possible now, that is also one aspect of the return.
But we will not be in a position to extend. You will have to give an explanation.
Yes, we have given the explanation.
No. Because this explanation for the purpose of counting cannot be applied here. You'll have to, when you file it, then you'll have to take this ground.
One difficulty was that the court fees is also there. If it is to be returned, that may be indicated. Because I think now, my lord, it will be difficult for us to make corrections by hand.
Correct.
In view of the latest notification, my lord. So
Correct.
that is there. Lord, should we grant us the liberty from 2 weeks? Within 2 weeks.
No. Because we are permitting you that return. But for the purpose of explanation, you'll have to still come forward and give that explanation. You do it in 2 weeks or you do it in 5 weeks, doesn't matter to us now. Because that extension of limitation was for 2 weeks as per order of 4/3/2020.
Yes.
Now we are in 2024.
Lordship. This
So
one,
therefore, it is only when you represent it and you give an explanation in your condemnation application, then that will be considered on merit.
that may be. My lord, the crucial thing is that, my lord, from 15/3 onwards, my lord, the COVID period kicked in. And
No. You see,
15/3/2020.
we don't have to condone anything right now.
I understand that, but this application was filed in 2021 when the Supreme Court's exclusion period.
No, that's okay. You give that explanation.
We'll give that. Lordship may only indicate in the order.
But Mr. Ganguly, counsel for the applicants. The respondents are unrepresented. Next paragraph. This, by filing this interlocutory application, the applicants have paid for return of the memo appeal in the connected RSA 285 of 2019 along with the court fees. Next paragraph. It is observed that by order dated 4/3/2020 passed in RSA 285 of 2019, the appeal was ordered to be returned. Obviously, the return of the memo appeal would be along with the court fees. Accordingly, this application stands allowed. The registry shall return the memo appeal of RSA 285 of 2019 to the petitioner along with the court fee. The next panel, the learned counsel for the petitioner shall of the applicant shall provide a photocopy of the memo of appeal to be retained in the record of RSA 285 of 2019. Lovely.
Lordship, I need to excuse Lordship. I'm sorry, out of town, I'm staying before Lordship. Lordship, the officer concerned already transferred or retired, I think, no, Mohinder? So I have to file a independent petition first, madam. New incumbent has to be included, madam.
What happens is, my lord, I was standing for two containers. One of them has expired and the other has debited office in the year 2020. So
No, you see
As of
that
now-
apart. This technically is apart. We just wanted to examine the appointment order.
my lord,
Do you have a copy of that order? No.
as of today, I'm.
The record
Well,
may be
this-
for.
Because we wanted to examine as to how far this contempt has been made out.
The appointment for Rubin Mohan.
Because there are conditions attached to the order.
Yes.
They will be paid salary from 2012 onwards.
Yes.
So what have you done with that part? That also we wanted to examine.
No, but the last instruction that I just went through, my lord, it says that this person has not been recommended for appointment. I don't know if he has been.
Not recommended.
Whatever was there in
Then the contempt
group
is there. Then the contempt is there.
Could be there because
But I read somewhere that he's been appointed.
in
Some
item number
document somewhere,
6
I won't remember where.
Then that record may be called for Lordship, then, because at present I have.
The-
also no
the
copy.
persons that I represent, none of them are in office. One is expired, one is out of
I
the
understand.
office. So unless the new persons are either implemented.
I have to visit new one, madam, new officers, new incumbent
item.
Lordship coming.
Strike out the earlier order. Strike out the earlier order and then say. Mr. Amir Ahmed, learned counsel for the petitioners, and Mr. R. Mazumdar, learned counsel for respondent numbers 1 and 2 are present. Next para, the learned counsel for respondent numbers 1 and 2 has submitted that as per his instructions, the respondent number 1
And
has
two.
expired.
No, 2 has expired.
Number 1 has been transferred.
No, he's retired.
Okay, he's superannuated on
2022, madam.
in the year 2022. And the respondent number 2, the respondent number 2 has expired. Full stop. Next para, on such disclosure, comma, the learned counsel for the petitioner 6. How much time?
All the people are scattered in different remote villages.
It's okay. How much time?
Maybe 4 weeks. 4 weeks maybe, my lord.
Please for 4 weeks time to
Implement the new.
obtain instructions and to file an appropriate application.
So there's only one
The-
petitioner in this case.
It will
Item
mention
6
that
only one
the,
petition.
only one.
One petitioner is there in the item
Okay,
6.
only one, only petitioner, not S. So the, what about respondent number 3? Who is he?
Respondent number 2, he was the then DEO. Someone was appearing, like some R Goswami was appearing.
Okay, the. It may be mentioned that the respondent number 3 remains unrepresented. Where the matter is called. Next, list after 4 weeks on a date to be fixed by the office.
Replacement.
Right. Item 19. 19. You go. Achha.
Item 22.
My lord, my senior is on leg in code number 27, and it will take some time. my lord.
Okay. After some time. My lord, maybe fixed on any other date, my lord, because. Any other day we just adjourn the matter on the day to be fixed by the office. My lord. On the prayer made by Mr. U.K. Das, Council of the Petitioner, the matter is adjourned today. List after a week on a date to be fixed by the office.
23.
Yeah, adjournment.
Lordship, require me, Lordship. Lordship, I appeal for respondent number 2 and 3, your Lordship.
Yes.
The counsel for the petitioner may kindly supply as a copy of the review petition. Lordship can take it up next week, Lordship. Because we are the respondent number 2 and 3. Lordship.
And then your lordship kindly issue notice, my lord, there. My lord, actually, although I file an application for review, I want some solution because my lord, some arising out of, because another 2 petitions are pending. So already, my lord, if I another 337 who are not before this honorable court, if they come, my lord, it will be very difficult for us. So
Okay.
so that's why if we go by recast, we've got 290, 190. 290 candidate already we have published and that was been accordingly appointment were made. So now if we include them, my lord, then we have to recast again, then my lord cutoff mark will be changed. So then another complication here right now. So I want to try to find the solution, my lord. So then my lord,
I understand.
my lord, that is the problem only.
I understand. But,
I try to find out a solution, my lord.
no, there's only one solution
My
to
lord.
the problem you have. I think appeal would have been a better choice.
No, my lord, actually, I don't like to go. Yes, ultimately, my lord, I have to go. But here, my lord, if any solution come, my lord, people will be benefited. And one problem is that, my lord, in this case, my lord, department did not come forward. Department did not place before anything, my lord. No affidavit has been filed. Because after getting selection, after giving selection,
Your
I
job is
submit
over.
our power is over. So now if I recast, then everything will be, my lord, changed. And similarly, the 37, my lord, they are also, although they are not before this honorable court, and 2 other petition are pending, my lord.
I understand.
So that's why, my lord, I am just to find out a solution, my lord. If there is no solution, then I have to.
This is a.
That is my.
No, you're right. You're absolutely right and fair. Nothing to say about that.
I have only told him, my lord. Yes, I don't like to debar you from this meeting.
Okay.
Your lordship, kindly issue notice, my lord. And I'll have a copy, my lord.
But Mr. T.J. Mahanto, Senior Counsel assisted by Ms. P. Sharma, Learned Counsel for the petitioners, also heard Mr. N. Upadhyay, Learned Standing Counsel for the Irrigation Department.
I'm for
and
4, 5 and
Mr.
8, Lordship.
N. Gautam,
And Gautam, Lordship,
Learned Counsel for respondent numbers
2 and 3, your Lordship.
2 and 3. Next, Pradhan. This review petition is directed against the order dated 24/6/2024, passed by this court in WPC 5182 of 2022. Next, issue notice returnable in. How many respondents are there?
She can appear for 6 and 7.
Your form?
6 and 7.
6 and 7. And Mr. Miss PR mounted on it. You are in her presence. Miss PR mounted on it. Standing counsel for respondent numbers 6,
2 and 3. No. One
6 and 7.
One notice has to go, Lordship.
Notice has to go to 1.
1.
So I'll take instruction in the regard, your Lordship. Both I can appeal.
Okay. Irrigation department, you say
4, 6 and 8, Lordship.
4, 6 and 8.
4, 5 and 8, sorry,
Oh,
Lordship.
so 4, 5 and 8.
Lord.
Okay. She's for 6 and 7. And Mr. Gautam is for 2. Issue notice returnable on, give a date after 4 weeks. And returnable on so and so. So requisite extra copies of the
My lord.
review petition be served on the learned council appearing for respondent numbers 2 to 8 within 2 days. Within 2 working days, make it, within 2 working days.
Yes, otherwise.
Next para, the petitioner shall take steps for service of notice on respondent number 1 by registered post with AD. Next para, list on
18/9/24.
18/9/2024.
Lordship, at this stage, Lordship, for respondent number 1, Lordship, I'll obtain instructions, Lordship. Lordship may kindly shorten the notice period to 2 weeks, Your Lordship. In case if I can appear on behalf of respondent number 1, Your Lordship, I'll file my Bakalatnama. In the meantime, Your Lordship.
No, because then there will be more delay. Supposing you don't get the consent,
Lordship.
then in 2 weeks notice
Again,
can't be
we have to
served.
take-
Lordship
And
can
then
issue
again,
notice,
we have to
Lordship.
issue 4
Shorten the
weeks.
notice period, Your Lordship.
No, I understand. But the service under General
Lord-
Clauses Act
Lordship,
27, we can't take.
Lordship.
Supposing you, when you appear, it's okay, fine and very good. But supposing you don't get instructions,
Lordship.
then what happens is that we shorten the notice, service report, we can't accept within before 4 weeks.
14.
Then again, there will be further more delay,
Lordship.
correct? If you, we can, you can do, supposing you get our instructions tomorrow, you can prefer this thing out of turn.
My lord,
Lordship. Lordship.
I need to cooperate, my
Ah,
lord, no problem.
Lordship.
List on the same day, 18/9/2024.
My lord. Only problem is that they should not come with a complaint, contempt, my lord. If they come contempt, my lord, that will be problem for us.
Huh?
If they file a contempt, because 1 month time was granted by your lordship. Within 1 month, we have to recast.
Lordship will not be filing any contempt.
No, just one.
Yeah, yeah.
Okay.
There are 21 deliberations.
As an interim measure until the next returnable date. The compliance of the order dated 24/6/2024 passed in the connected WPC 5182 of 2022 shall remain suspended. However, this interim order would be subject to further orders that will
My
be
lord,
passed on the
Lord,
next date of this.
Item 24.
Yes.
Sorry, my lord, I filed an appeal, my lord. It was actually this order is given on 26/7, my lord. Actually on 24, another matter was heard in the presence of learned Advocate General, my lord. The division also of the view that the what I had said there, my lord, I should have said here. my lord. Therefore, with liberty, my lord.
Okay. Where is the appellate order?
Appellate order, my lord, page 108, my lord.
Page
108.
103.
108.
8.
109.
Okay, then we issue a notice. We'll take it up next week.
Yes.
Heard Mr. S.K. Royal and counsel for the petitioner. Also heard Mr. B. Chaudhary and standing counsel for the SCERT.
SLRC, no,
S-
SLRC.
SLRC. Mr. D. Upamanyan and standing counsel for the Health Department. Ms. S. Mushari, Leonard.
H. Terampi.
Oh, I'm sorry, A. Terampi, Leonard, counsel for respond number
Number 5, Your Lordship.
5, and Miss
DG.
D. Jane, counsel for respond number
Three.
6.
Three.
3, okay. Others are not there?
No, Lordship. So I'm for 4, 7, and 8.
Health is 4, 7, and 8.
My 6. I'm for only 6, Lordship.
Mr. Chaudhary for 6.
Personnel department. Personnel and.
Terampi for
Terampi for
5, Your Lordship.
5. Miss Jane is for 6.
Yes, 3.
3. Who are left out?
1 and 2, Lordship.
1
Who are
to
they?
comment, madam. G.
Government. Lordship.
Government.
Government.
1 and 2. Who will appear for government?
Government.
Suggest a name.
Lordship, may give Mr. Dina's name, Lordship.
Mr.
Same.
Dina. Senior government advocate appearing for respondent number 1 and 2. As all the respondents are represented, no steps are required to be taken. Instead of however, requisite extra copies of the review petition be served on them within 2 working days. When should we take it up?
Lordship, any date subject to Lordship.
Hmm?
Any date, Lordship, subject to Lordship.
Okay.
No problem. Thank you.
List after a week on a date to be fixed by the office. I'm not giving a fixed date because the.
Yes,
I'm taking a
Lordship is
revision
sitting
bench.
Yes, there are, madam, other review petition also there, madam.
No, it's okay, but I'm not giving a date because I don't know about the roster.
Yes, yes.
That's why.
Always.
25.
Wait, please, Your Lordship.
Yes,
But the review petition was a very small point, though.
it's never ending.
No, it was not that. On that date, neither they, nor us, or not anyone knew that there was those documents were actually served upon the government and all. So therefore, in appeal, we had put those documents. I said it was because that those questions they never came up for the first time. But the appellate court, and rightly, my colleague had objected, said that you do not introduce here, go there, and therefore liberty to file the review. Only on the point that 43(8), so far as this petition is concerned, that is
We
6
issue a
to
notice, we'll
4.
take it up next week.
It
We
can be
issue a
disclosed
notice.
only on that. No, he is for all.
No, I understand, but
I-
I have to, since
I
I'm
know.
taking up a review, I have to give a formal notice. Heard Mr. S. Banik, learned counsel for the petitioner. As well as Mr. V. Rajpal, and standing counsel for the Corporation Department. Was a bid for all the respondents. Next one. This. Where is the appellate order?
Appellate order, my lord, finds at page 33.
34.
This review petition is directed against the order dated 30/4/2024 passed by this court in WBC 6243 of 2023 and connected matter.
We are only on that, 6243.
6243.
I am on so far as 6243.
Oh, okay, WBC 6243 of 2023. You have made other writ petitions party here.
No, need
No.
not, my lord. Because
No, then you see, it's a common judgment.
maybe, but if I just pointed out why, I may be wrong, we can do that. We can even withdraw and refile, that's not the issue, madam.
No, we'll tell you why. Insofar as the other writ petitions are concerned, that will attain finality. So there cannot be a second opinion in one writ petition.
There
when
can be.
common.
That's what, if I may persuade my lord on that. My election proceedings were not approved. I filed 6243. Okay. The other team, they unilaterally hold an election. Theirs were approved. I moved to the registrar and all.
registrar does not interfere. I filed the second writ petition, the other writ petition. Now, their AGM and all, so far as their removal, that was disapproved. My chairman was brought in, therefore they filed. So now two rival groups are filing, they're contesting, they're holding elections. Now, if 43.8 is to be satisfied by vote, my case is I satisfy 43.8. They are not in review to say that they satisfy 43.8. The point remains valid. Only what I pray is that for review in the touchstone of these documents, that my documents were there. If they feel the urge to place that on record, certainly they may find a review. Otherwise, that's all. That is what I'm seeing, Milord. Two contesting groups have held AGMs.
No, just give me answer to one query. If in your petition,
My lord.
In this
6243.
6243, if the opinion is altered,
Not altered.
no,
43.8 is maintained. 43.8 is maintained. It is not that 43.8 is gone. We are not taking a review of that.
We're not saying that. Supposing this opinion rendered in this judgment is altered, what happens to the other petitions?
The requirement of 43.8 was never under challenge, nor in review. What we say is that we had complied with 43.8. That could not be brought before your lordships. Now on discovery, we are bringing it. We went in appeal to say so, but the fitness of things, review was fine. That's all. If the other camp says that no, we had also complied, let them come in review. Otherwise, 43.8 is valid. Nothing wrong with the judgment. It's correct to say that we must comply with 43.8. We have shown compliance. That's all.
But that means that means the opinion would be altered.
Not altered. So far as ours is concerned, we had met 43.8. Lordship's view was that since both the groups had not met with 43.8, all the AGMs gone, nothing remains. Now you take over and do. All right, take over and do. Here is a case, if I satisfy, this is the documents, my lord. Lordship is satisfied. Okay, one group has 43.8. So far as this is concerned, there is 39 does not apply. That would be the answer. If the other group is not even aggrieved as on date, no appeal, no review, I did not make them a party, neither necessarily nor proper, not anyway. Because they would be aggrieved by your lordship's observations so far as they are concerned. I understand.
They probably may affect the other party. Lord
I don't know, I'm leaving it.
No, he cannot lip sync to others, they are the corporation.
I just wanted to highlight one aspect.
I'm not, no, he's giving his
fair enough.
opinion. He's not on that. You see, the question is that I have not applied my mind, how this order would affect the other
I
petition.
leave it to you, lordship.
You say that it will not.
I say if there are two groups and lordship holds the same yardstick for both the groups and we both fail, and then one group comes up to say, I complied, but I could not place that day. I did not have that opportunity or the information whatsoever. And seeking a review to that extent. Not that the principle is wrong. What I say, I comply with the principle.
But the effect of the order.
Nothing. The other group, if they are aggrieved,
No,
they say, no, we are also complied. They may
please
come for.
Come to this. Because now the direction in paragraph 12.
Paragraph 12.
Is that the ARCS will take up their management.
Correct.
So if
They are still taking up the management, no difficulty with that. Secretary is common, whichever camp he may be, I'm not disputing that. Because someday they throw the chairman out, the chairman will throw the secretary out, which all who gets the power. Now, we are not making his minding, it's good. So what happens is that they are operating with the secretary. I am not disputing. Everything is correct. What we say is that very tactfully drafted, that we have met with the condition. Kindly consider that much. We are not even aggrieved by anything. Now the other camp is not aggrieved.
Very simple answer. Let me hear it. Mr. S. Banik, Learned Counsel for the petitioner, and Mr. V. We already said, no? So this is directed against the order dated. So in WPC 6243 of 2023. So it is submitted that the said order, comma, it reviewed could not affect the other linked cases.
Yes.
Next paragraph. Issue notice returnable in 2 weeks. Stop. as all the respondents are represented, no fresh steps is required to be taken. However, requisite extra copies of the review petition be served on the learned standing counsel for the cooperative department within 2 working days. Next list after 2 weeks on a date to be fixed by the office.
Let's have the copy.
Public.
No end to this litigation. Mr. Bani, no end to this particular litigation.
No, it will end now. There needs to be some controlling factor. If I may just indicate, without the case, now we are off the case. What happens in cooperative societies is, it's a power game. And secretary, if not appointed by the government, is a very free person. So whichever body is there, either the secretary is shown out or the chairman is shown out. And even if the court sets aside the removal, again, which comes into power will throw it out. It's a continuous loop. Now, here is a case where my lord would consider those documents to meet. The other kind does not have it. So they have neither file review nor in appeal. It's good for us. Obliged, Lord.
Many things yet to learn.
We I would learn
Here
that.
also.
Timing item 15.
15 lordship, both the containers, they were already retired long back, lordship, Pitam Soke and Jidung. So it would be better for him if he implemented. It was last listed on 8/5/23.
No, I think we called you on that day. To
Yes,
find
because
out who are the officers.
yes.
It will be easier for. Him
Yes,
to-
I will give him the, I'll give him the name. My name to Didi.
Okay.
Yes.
So we'll dispense with your presence.
Yes. Yes.
He's not the.
Lordship.
counsel.
Yes,
We
I'm not the.
we requested him.
Yes.
Okay. We requested him to just for information.
Yes. What are he did, huh?
Mr.
DC Nath.
DC Nath, the counsel for the petitioner is present. First off, Mr. SMT Chesti, learned standing counsel for the secondary education department, has appeared pursuant to order dated in pursuance to order dated 8/5/2023 and has submitted that as per and has submitted that that both the respondents have retired long back. First off, next, accordingly, he is requested to provide the names of the officers who are holding the post of respondent number 1 and 2. Next para. The further appearance of Mr. SMT Chisti, learned standing counsel for the secondary education department, is dispensed with. Next para. The registry shall not reflect his name in the cause list while listing the matter next. Next para. The petitioner, after putting the new incumbents to notice to comply with the directions of the court, shall take steps to implement them, if the order is still not complied with. Next para. The pendency of this contempt petition shall not be a bar for the compliance of the order dated 16/7/2015, passed in WPC 3958 of 2021, which was affirmed by order dated 27/2/2019, passed in WA 273 of 2018. Next one, list after. How much time?
Lordship, after
2 weeks?
2 weeks.
List after
Lordship,
2
I mean,
weeks.
3 weeks, Lordship.
Three,
In the
out of
meantime, I
3
will
weeks as
also
free.
take the information whether the
Okay.
benefit.
After 3
get
weeks as free.
পেনশন দিব লাগিব
Okay.
জনাব লাগিব
All right.
Dispense with your presence.